Welcome to the October 16th hearing of the Zoning Board of Appeals. Just checking to make sure everybody's in the right room. We're not the planning board, we're the zoning board. Tonight, Kathleen O'Donnell is me, and I'm the acting chair. And joining me on the appeals board tonight is Frank O'Brien to my right and Nicholas Gray to my left. When people are coming up to speak, if you could make sure that you're using the microphones, not because we can't hear you, but because the proceedings are being taped, and so you need to be able to be heard on the tape. We have 3 matters before us this evening, 2 which are continuations, 99 Granite Place and 5 Badger Circle. The first new application is 285 Edge Hill Road. And I believe that's the first item on the agenda. So people for 285 Edge Hill Road. Good evening.
Good evening.
McKettrick.
I'm Marion McKettrick, and I represent the applicant, David Connolly and Jean Sarah.
Yeah, and Jean's my wife.
Great. And so we have this application that has been submitted in response, I believe, to an enforcement letter issued by the Building Department Inspectional Services on June 25th, 2018, notifying Mr. Connolly of 285 Edge Hill Road of a non-permitted second dwelling at 285 Edge Hill Road. There is apparently a detached garage with a dwelling unit apartment above it. In the materials, we have the inspector's letter of June 25th, 2018. We have an application dated August 22nd, 2018, to which is attached a letter dated August 22nd, 2018, from Marion McKettrick to the Board of Appeals, making a case for the request for a variance. Attached to Attorney McKettrick's letter is a copy of a plot plan issued in 2018, August 2018, I think, looks like. And our drawings of the improvements at the carriage house, together with a property record data from the assessor's office. And I think this may be a copy of the records at the building department, this schedule?
Yes.
Yeah. Along with an assessor's plot plan and a copy of a deed to David Connolly and his wife Jean Sarah, recorded in August 20th, 2010. And I believe that's all the information, that's a summary of the information that we've received.
Thank you. I have an additional memo with a little bit of additional information that we've gathered since the time that we filed the application. I gave you a copy already. That's just one copy of that from here. Those are just the actual deeds and the champ title, if for some reason wanted to look at them. So I just have a summary that I provided to each board member. So, would you like me to begin?
Yes, please.
So I represent David Connolly and Jean Sarah. They purchased their property at 285 Edge Hill Road in 2011. And at the time they purchased, they understood that they had an apartment. They have a large Victorian home, a very beautiful home on Edge Hill Road. And the lot is about 17,000 square feet. There's a carriage house in back of the house. And the carriage house has an apartment in it. And when the applicants purchased in 2011, the apartment was there, and it had a tenant. And they were led to believe, and even looking at the assessor's records, they thought they had an apartment that they were legally entitled to use. So they continued to use it and rent it. In fact, the current tenant has been there for 4 years. This summer, they filed a building permit application because they wanted to put a new heating system in the carriage house, and at the same time, they were going to put a new, more efficient heating system in their house. And it was all part of a project that was being paid for together, And they just, had no idea, actually, that when they filed their building permit application, they would receive the news that they had an illegal apartment. But that's what happened. And I talked to the building inspector, and he did agree to let them put the heating system in because the building would need a heating system no matter what its use was going to be. So that part of the enforcement letter, he agreed to let them go ahead with, but we filed this application in order to discuss with the board whether they might consider granting a variance for the apartment. I guess some of this information was in my application letter, but after we filed the application, I went through street lists to try to see what the residency records indicated for this address. I went through in more detail building department records, assessor's records, and I looked at the entire title history to get some idea of who had been living at this address. And in general, I just tried to gather a lot of additional information that I thought might help, even in some cases more than it did in the end. If I had found that there were people living at this address before 1938 and they all had different, number of them had different last names, well, that might have been an indication the apartment was in use then, and it possibly was being rented to somebody who wasn't a family member. I've used these street list records a number of times. They're useful. They don't really answer all the questions, and there are a number of reasons, but one is that even when a family member is living there, sometimes they have a different last name. Today, it's quite common, and years ago, it was common because you'd have an in-law, your mother-in-law would be living there or something like that. So you can't always tell from the street list who's living where, or whether there was a separate unit. What I did find was in 2006, I found that the street list began to list 285A Edge Hill Road as an address, and someone with a different last name at 285A Edge Hill Road. And that same person was listed for 2 more years. So for 3 years, that address is listed. Then there's 1 year, the next year, there's no name listed. And the following year is the year the Connollys and Sarahs purchased the property. They tell me that at that time there was a tenant in the apartment. The purpose of looking at that period of time was partly to just see if at least the renovations that had created the apartment might have been in existence for more than 10 years. And I also looked at building department records, and I found that in 1991, there are very few building permits in the records, which isn't that unusual. But there is a record in 1991 of a new bathroom having been installed in the garage, in the carriage house. And at the same time, or approximately the same time, it appears that a pool was built in the property. So who knows what else was put in and when, and whether it occurred in 1991, whether there may have been a separate unit there a long time ago before then, and people have been renting it. The paper records were only really able to tell me that much. I did find out by looking at the title history that one family had owned this property for about 50 years. And during the 1930s, because in 1938 the town adopted its zoning bylaws, there was a family of 2 parents. I can tell by the ages in the street list. I deduced that it was 2 parents and 6 or 7 adult children living at this address, at least during the 1930s and into the 1940s. Again, it's possible that there was a separate unit in the carriage house, given the family composition, and that family members occupied it. But I don't know, and I don't have any other evidence that that might have been the case. So we're coming to you today basically to say that the apartment has been in existence for a considerable period of time. It's a very attractive apartment. It's not big. There are two parking spaces on the ground floor. There's a 1-floor open plan living room kitchen, and then there's sort of a loft area above where there's a sleeping area. The current tenant is a single person, and I believe they have 1 car. Is that right?
Just 1 car.
So there is adequate parking area on this property for the use, because there's a driveway that's long enough for probably at least 2 cars behind each other, and then next to each other another 2, and then there are 2 parking spaces inside the garage. There's not been a parking problem, and there's no need to park on the street. So the use is not causing any kind of detriment, I guess, to the traffic, and it is a very busy area for traffic. Edge Hill Road is a busy street. What we did do was, Mr. Connolly has been meeting with his neighbors and talking to them, and if you have no objection, I'd like to ask him to report on that. I think he may have a couple of letters and some signatures, and to tell him what the neighbors have been telling him about the use.
Sure, thank you. So I did over the past few weeks just approach a number of my neighbors after the notice went out from about the public hearing. And pretty much everybody assumed it was a legal apartment and had no issues whatsoever with my seeking a variance. At Marion's direction, I asked if there were any conditions they would like to see imposed upon renting it. And I know with our application, we had submitted a couple conditions, which frankly, as the property owner, I think are common sense conditions for the apartment. But I knocked on a bunch of doors, and I have about 20 signatures here with names and addresses to submit to everybody who, not one person said no, and everybody said, you know, if we can help, we would. Did have one neighbor who knows the Caseys, who had lived there for a while. I'm sorry, Joe Callahan. Lives across the street on Plymouth Ave. He would have been here tonight. He told me it's been rented for at least 20 years as an apartment. He lives right across Plymouth Ave from the apartment. He, however, has fallen and is in the hospital. He's 90. And he and his sister Rita live in a house across the street on Plymouth Ave. I do have 2 other letters from Plymouth Ave neighbors. I focused on Plymouth Ave because my driveway
Is on that.
goes out to Plymouth Ave, and these are the neighbors who were most, cognizant, I guess, of the apartment. And it's basically the very next door neighbor whose driveway is adjacent to mine and whose house is probably less than 15 feet from the carriage house. And then the second neighbor is across Plymouth Ave. So the first one is John Linsky, who lives right there on Plymouth Ave. He grew up in the house, and he's probably in his 50s, and he's living back there by himself now. And he grew up in that house and remembers everything that Marion had just said, including the renovations in the early 90s, and including, he thinks there's been tenants in it, people living in and out of the apartment for the better part of 20 years to 25 years. And then the second letter is from Jeff Green. He moved into the neighborhood 10 years ago, just 2 years before we did. And he also says he has no problems with the apartment. And as far as he knows, it's been rented prior to his living there as well. And then I think we assumed there was no problem with renting it as an apartment. As I said, it was represented to us when we purchased the property as having rental income, which certainly helped for us to purchase the home. And then second, the tax records seemed to tax the property as a multifamily. The fire department, when we moved in, checked all of the smoke detectors, including the smoke alarms in the apartment, and checked that off, so there was no problem there. And then lastly, what gave me no pause whatsoever was the fact that there's a 2-family right next to us on Edge Hill Road. Mr. Callahan, whom I mentioned, is on Plymouth Ave in a 2-family home, and on the other side of the Linskys at 1921 Plymouth Ave is also a 2-family that was recently renovated, and I just didn't think anything of it. And frankly, it was part of the reason we were able to purchase the house and hope to gain the variance to be able to keep renting the apartment. And I have photos as well. I did get 3 sets. I don't know, they're not great, they were just taken today, but show the apartment, the carriage house, the driveway, and the front of the house, so you can kind of see how it looks in the neighborhood. I don't think,
3 sets here.
yeah, there are 3, there's 3 sets of 4. So there's 1.
There were 2. Thank you.
No, that. Thanks.
Oh, okay.
I did.
One of the things that I noticed when I met with Mr. Connolly when he first approached me about this property, and we went through everything, and I the building commissioner had already advised him that he was in violation. So the first thing I did was answer the enforcement letter. But I've been inside the house, and it's a beautifully restored Victorian. Hopefully, it's been like that all along, or maybe you did a lot of work on the house. But it's obviously a property that's been maintained in a really distinctive fashion, and it's on a very large lot compared to other lots in this neighborhood. So I believe, I think it's likely that the income from the apartment has contributed to the ability to renovate and maintain this really beautiful historic property. I think that has a value. I don't know that it's listed in our zoning bylaws. It's certainly in our master plan for the town, that the preservation of historic properties, as well as, trying to provide a variety of housing types, those are both goals in the town's master plan. So in trying to argue for a variance, I've argued on the one hand that, there's no substantial detriment to the neighborhood. There's a real track record for this use, and there haven't been any neighbors that have said that it's a problem. It enables the property owner for this property to maintain a large, expensive, beautiful, historic property. It really stands out on Edge Hill Road, and I think everybody probably enjoys seeing it as they go by. It is possible for the town to grant a use variance. We do have that provision in our bylaws. It's not necessarily allowed, unless the towns do allow for it in the local bylaws of the cities. You cannot grant a use variance, but we do have that provision in the Milton zoning bylaws. And I feel as though over time, a large lot like this often gets subdivided. Probably one reason it wasn't is that the carriage house is partially on one lot and partially on the other, and it's always been that way since 18, the assessors say all these old houses were built in 1893 or 1899, but, I think it might have been even earlier than that. But in any case, the carriage house is just as old as the main house. And finally, in the letter, one reason I gave you this additional letter today, or memo, is that we did think about conditions that the board could place on such a variance where they consider granting it, and I'd like to read them. And you may think of others, but I do think the conditions also help ensure that this use will not become more detrimental to the neighborhood, or will not be a detriment to the neighborhood. So the first would be that there's to be no increase in the size or footprint of the apartment, as shown on the architectural plan submitted with the application. That the property owner provides a condition in the apartment lease that the tenant may own and park only one car on the premises. That the apartment must continue to be a single apartment owned by the owner of the property and cannot be converted to condominium ownership, even though the assessor's records say that there's a condominium at this property. There isn't, so they describe it that way. That the apartment lease be for a long-term rental only, a year or more. That the exterior of the carriage house be preserved in good condition in its present historic appearance and continue to match the exterior of the house. And that while the apartment use continues, there be no subdivision of the property. So those are some suggested conditions.
Thank you.
You're welcome.
It troubles me to think that the rental income was important when you were buying, but that nobody took a look at the occupancy for the house. The assessor's records don't create multifamilies. Occupancy permits do. And I really kind of fault whoever was representing you when you bought this for not looking at that, because that's a serious mistake. It happens, unfortunately. I've seen it happen a number of times. You have to check the building records. It's a single-family house. It's never been a multifamily, whatever the assessors call it. The occupancy is as a single-family use, so that's why you got the stern letter that you did. So as I said, that sort of troubles me that such an important component to your purchase wasn't accurately investigated. That's a real...
We understand, or at least certainly Connolly's understand. Mr. Connolly understands it now, and yes,
it's a real gaping hole.
that's true.
So, do you have any questions that you wanted to?
There, trying Attorney McKettrick, there was something in your letter, or whatever it is, memo, that stated that because it had been longer than 10 years, what's the
Well, the
remind me what that
structure,
says.
actually, it's a structure that's been in existence more than 10 years.
Okay.
And reconstructions that have taken place, and even though they may not have been done legally, if there has not been an enforcement action within 10 years, they acquire what's called non-conforming status, which is a legal status. The use is another matter. I mean, it's confusing a little bit, but I don't think a use really does. I think that you know, if it's a use by itself, you get the order, you have to stop. And perhaps that's because you haven't changed the structure necessarily for use. In this case, all I can say is, you know, a lot of investment's gone into reconstructing this, and I don't think that there would be, that the building department, that the town would be able to order that the work be deconstructed. It's the use that's at issue.
Okay.
They have ordered that the use be discontinued because there's no variance that allows it in this district. And we have no zoning bylaw that says that you can have a carriage house and rent it as an independent rental. You could have a caretaker living in a carriage house. That's one provision that our bylaw does have. And, I mean, you could rent to somebody and have them be your caretaker. And in a large, beautiful house like this, that would be conceivable here. That would be the way you would be able to approach this as an allowed use. You wouldn't need a special permit to do that. In this case, it seems to have worked very well. It's an unusual situation. It's a very, it's a beautifully preserved property, and I think this is part of the way that it's been preserved. So I guess my argument is just that in this unusual circumstance, I think that it might make sense to allow it to continue.
But how do you reconcile that against the spirit of the zoning code, which is basically very hostile to these types of uses, to the use of apartments in general? How do you reconcile the overall tone of the zoning code to that, to what you're asking?
You mean the Milton zoning code, I assume? I guess. Well, we do allow different types of apartments. We don't allow this. We allow a two-family, and there are two families surrounding this property. It wouldn't make any sense there's enough room to create a two-family here, but I don't know if that would strictly comply. It wouldn't comply because we have very limited two-family conversion. You have to have a house on each side of your property that's a two-family. I think there are circumstances where sometimes something has gone on for a very long time. It has worked very well. It has not caused any intrusion. And it can be limited so as to not cause any future problem. And the neighbors seem to support the use. There hasn't been anybody saying that it should not continue. And under those circumstances, I think the board should at least consider whether a variance should be granted here.
So basically, your
Basically, I
argument
can't tell you that any variance is a request to do something other than what's allowed by the zoning bylaw. Any variances. And yes, that's what this is. Is it inconsistent with the objectives, which are to protect neighbors and maintain a residential appearance and have, although we don't have wording in our zoning bylaw at present, I think there's a strong desire to protect historic properties and keep them in good condition. Yes, it does do that. So I think it would provide a benefit to be able to continue to do this to the neighborhood as well as to the individual owners.
Okay.
I mean, I'm sensitive to the fact that, yes, the improvements have been there for more than 10 years, and so there's no ability to enforce those provisions to haul out the plumbing and the kitchens and all that sort of stuff because the 10-year period is gone. I'm scared about the fact that people have done that work without getting permits. I mean, Lord only knows who put it in and how. But, it's, you know, that's an issue. I'm appreciative of the conditions that have been offered. I think if we were to consider it, I would certainly want to incorporate those conditions. I don't think it fits into the special permit category. I mean, I think we're really looking at having to issue a variance. And, you know, I'm troubled by the fact that we don't really allow accessory apartments unless it's a family member in a certain condition and, you know, that's, it's temporary and,
We do allow a caretaker apartment in exactly this
Yeah.
type of structure.
Right.
And it's an old house, and I suppose that's what people were thinking about.
Yeah.
They were thinking about when you had servants and you know, and today people do that as well.
yeah. And, I mean, I also, because of the master plan, I mean, I know that we've really tried to look at, and we certainly, you know, in East Milton, where I live, the issue of rentals for people is a tough one. There aren't that many available. And so the idea of providing a rental in a place that, like Edge Hill Road and near East Milton Square is great. I can see that that's a good benefit, but I'm really troubled by the fact that we don't have some, you know, ability for accessory apartments, single-family dwellings.
I mean, I know it's been before the legislature, it's gone to committee, it hasn't come out. And again, I don't even know what the legislation would be or how it would affect Milton or whether Milton would have to adopt it in order
Yeah.
to follow it. So it's not something that's happened yet.
Right, right.
I think it's a good example of how it can work well. I guess that's the best I can tell you, honestly. And it's an interesting situation to me that it could have worked that well and on such a beautiful property.
So the basic argument is that it's always been this way, and no one's objecting, and so consequently, we should go along. I mean, to be blunt about it.
Yeah, I mean, it was quite important to me to find out what the neighbors had to say and how long they had lived there, how long they had observed it to be there, and whether they had felt that it had created a problem for the neighborhood. We didn't hear any of that.
And the other problem, they have a tenant. Who would have to find someplace else.
Oh, if we don't grant it, yeah. What troubles me is a couple of things, but one of them is just that the gist of the argument is that it's been in use for a long time. So when I was reading this at home, what crossed my mind was, okay, so it's been illegal for a really long time, and therefore we'd like to continue the illegal use because we'd like to regularize it, and the main reason is because it's been that way. It's been wrong. Not you breaking the law, but it's been an unpermitted use for a substantial period of time. And the other bits about it being helpful to, support the upkeep of the property, I certainly understand, given how expensive it is to keep Victorian houses up to snuff, having owned them, is important, but I'd like to hear what my fellow board members have to say, but it's hard to think of what precedent might be set if we use length of time for a violation to be a reason to justify approving, regularizing it. Maybe, I'd let you guys like
Yeah,
more
I mean,
about it.
I'd ask, I understand what you're saying, and I don't disagree with it.
Yeah.
I think that it's a combination of factors in this case that makes me say it's worth it to at least go to the Board of Appeals and
Yeah.
ask them.
I mean-
And that is that it is a beautiful-looking building,
Yeah.
a beautiful home, and a large lot, which, comfortably supports this use.
Yep.
You're just not going to find this. You might find this maybe up on Hillside Street somewhere. I mean, you're not going to find it on Edge Hill Road near East Milton Square. It's quite unusual. The property's pretty unique, and it has been carefully and tastefully done without impacting the neighborhood. I think those are positive factors to consider. They're not, I understand, you're right.
Yeah.
My argument is it's been going on a long time. We're not sure how long. I couldn't determine that it started before 1938, so I can't come to you with that argument. But
The other concern I have is, so I get how unfair this is
Yeah.
and how unfair it sounds, because actually, the building owner's done the right thing. The building owner wouldn't be before us if he hadn't done the right thing in terms of applying for the building permit. So in a certain sense, the owner is probably feeling like he's being punished for doing the right thing. And clearly, the building owner has done the right thing because the property is very nicely maintained and the neighbors don't object. What about the next owner? What about the next person who wants to wants to regularize a use? What about the precedent here? It's one of the concerns I have. Frankly, I'm wrestling with the precedents versus what I see as an unfair situation.
Exactly.
I think you're right to be wrestling with it. I think that you'd have to find all of these factors applicable to another case to say for sure that you've established a precedent. You're not just saying, well, anybody, just based on the fact that there was something done illegally, that you're going to go ahead and let it happen because it's been there for a while. I think there are a number of other characteristics of this use that make it not substantially detrimental to the neighborhood, and the same arguments are there to continue it because it's been there and because the homeowners thought that it was legal and so forth. And yes, indeed, they went to the building inspector and applied for a building permit the way you're supposed to, and that's why they are here. I suppose they could have just continued, as has been going on for all this time, and nothing would have happened if they hadn't come in and applied for that building permit. So I think they deserve a little credit for having followed the proper procedure, but this is how it is. I'm very cognizant of the concern about precedent and not getting sloppy and just letting people do these things somehow because they decided they were going to do them 20 years ago. It's okay now. We'll just say okay. I think that this is an unusual situation and perhaps should be allowed. That's all I can tell you. I don't think it's typical. I don't think you're going to find a lot of situations like this.
Yeah, and I'm, in all honesty, willing to accept whatever conditions, and attach them to the deed or however that works. I'm not 100%, but whatever seems to make sense. We have a good, solid tenant right now. It is our home. I mean, we have 2 children, so we're not going to rent it to gypsies or anything along those lines. It's important to us to have the right tenant, and I'm sure whoever owns the home after us would be willing to do the same exact thing. So, and if we write that in, that's would be perfectly acceptable to me.
When I gave you the suggested conditions, I tried to include some conditions that related to maintaining the historic appearance of the house and the carriage house, because I think that's part of my argument.
Those are nice. I think the probably the one that I'm trying to think of a way to craft a variance. I mean, you don't limit them as to time the way you can with special permits.
That's true.
You give a variance, you give the variance. So you can't say, oh, it terminates upon the sale of the property, which would be one way to do it. So I don't think
That's
that.
what I was thinking too, but it's the same.
Yeah, so I mean, because the special permits that we give for accessory units, those are time and all that stuff, but you give a variance, you give the variance for forever. So, to say that, it has to be, that the main dwelling has to be owner occupied, the ownership has to stay the same, so that you're not, splitting it up and, turning it into condos, or not that you really could, but, those kinds of things to sort of limit the appeal, I suppose. You can't expand it. It has to stay looking the same. I can't think of a way to sort of trigger a termination on the sale. So that's what's kind of giving me a problem.
I mean, your client comes here with a fair amount of credibility because of what's going on. It's the next guy.
Exactly, and I'm, of course, I know you can't time limit a variance, but I was trying to think of ways. I mean, I certainly talked about the size of the apartment, how much, you can't really talk about the family composition, I don't think legally. If you talk about how many cars can be parked, how large the apartment, it can't be any larger than it is now, that kind of thing
It's one
keeps
bedroom.
it the same way.
Well,
it
I
is
think
now,
that
but-
the idea of limiting it, that it has to be a yearly tenant
Yeah,
is huge.
and a long-term
Because,
lease.
you know, this is an issue that lots of towns are facing these days with people doing that with Airbnbs. And they wouldn't be before us. We wouldn't even know about it. So the idea that we have a tenant that has to have a lease, that they're there for a year or more, cuts down on that problem. Because people are doing that all over the place without any supervision whatsoever. So, you know, we're at least in a better position in this situation with being able to put in some terms and conditions, which we can't on people that, you know, just renting their houses out, you know, willy-nilly. So, it's, but you know, I'm concerned too about the precedent that would be set. We really would have to, the decision would really have to put in, I think, a lot of background as to why, if we decided to grant it, we did in this case, and so that it wouldn't hold us to the next one.
I mean, I'm thinking of, you know, if that was the case, if we were going to that particular direction, then the conditions / restrictions would have to be fairly rigorous. And, you know, for example, going back to Airbnb short-term rental, that the tenant wouldn't be allowed to sublease the apartment. The tenant would be allowed to go through some sort of short-term rental arrangement. That the number of vehicles parked on the property would have to be limited, because the condition that's been proposed here makes mention of the tenant. Well, what happens if all of a sudden we have a couple on 2 cars? Now, I know it's a 2-car garage, or two garage doors, and the driveway would take 2, but you have to take that into consideration.
The limit in the zoning bylaws is 5 cars. Were you thinking of less than that? I mean, you can put a condition in a variance if you want.
I mean, we could legitimately park 6, 3
But
bumper to
legally, you
bumper.
cannot.
Okay.
You
I mean,
cannot have more
I
than
no
5
reason to, but
on a residential
except on
property. So 5 is the limit anyway.
Okay.
The question is, well, first of all, I don't know how many cars you have, you know, personally. So,
So we have 3 for our nanny who lives in our house with us, and then my wife and I each have 1, and our current tenant has 1.
so there are 4 now.
So there are 4, and it's always been
So where does everybody park?
In the driveway and the garage.
driveway.
In the driveway that we're talking about?
Yeah, yes, that's the driveway for the property, and it's, is the driveway on the plot plan?
Yeah.
Essentially, the tenant parks in the back corner, and we slip in and out, and she never has to move our car, and we never, never have to worry about that.
All right.
This is the driveway here, right?
No, it basically runs the width of the carriage house itself. It's a little wider, but.
Okay, so this doesn't really show the driveway. Would you draw it in so I can show
Yeah, so the
them?
driveway.
It's actually kind of interesting that you just mentioned the living arrangements. Frankly, the nanny lived in the apartment.
I was just thinking the same thing. I didn't say anything.
But if you went in the house, it's a huge Victorian house. Yes, you're right.
No, I mean, if the nanny lived in the apartment, we wouldn't be here, which kind of leads me to the incongruity of the situation.
Yeah.
You know, I mean, frankly, maybe I'm coming around to where you are, in the sense that it's an unusual situation. I am troubled by the fairness, but I'm really troubled by the precedent.
Yeah.
So, I mean, it is a nice home, it is a large lot, but there are a lot of nice homes, there are a lot large lots, maybe not in that particular neighborhood. remind me, what's the two-family situation in that, surrounding that?
There are two families
So, I mean,
at 285 Edge Hill Road, 290, I'm sorry,
no, that's mine.
I'm sorry. That, yeah. 297 Edge Hill Road, which is across the street, at 20, 19 to 21, that's one address, and 31 Plymouth Ave.
All right.
So directly across the street on Plymouth, on Edge
Yeah.
Hill, you know, it's a corner lot just like this
Right.
one.
Yeah.
That's a two-family. I did give you a map here, so if you look at that.
On the
Yeah, and
assessors.
then
can show you.
on our side of Plymouth Ave is my house with my driveway going out to Plymouth Ave. And then 15 Plymouth Ave is Linsky right next to me, and on the next side to him is a two-family, a stacked two-family. And coming in the other side of Plymouth Ave, behind the two-family that's on Edge Hill is a single family, and then the next house is a
Yep.
two-family, but it's a side-by-side duplex. And that's where the Callahans have lived for 90 years.
Okay. All right. I think
right.
I've made up my mind.
I need to hear what you guys have to say, because I'm struggling.
All right, well,
I want to help, I really do.
well, I'm a practical politics kind of guy, and I'm really troubled by the unfairness of this.
Yeah.
So I think that I would be prepared to support the variance here. I think Mrs. McKettrick has convinced me, weighing the balance of the equities. Going back to law school
Where I
here.
work is in equity, so.
So weighing the balance of the equities here, what's fair versus the precedent? So what's fair here is that, so it's a big house, nice lot, well-maintained. Somebody along the way screwed up in terms of not checking the occupancy permit of it. The owner is not a lawyer. Assessors have assessed it as a multifamily. How would the owner know, unless they had a real estate attorney, to go ahead and look at it? Unless they were a sophisticated investor or sophisticated buyer. It's in good shape. I think that we can put a fair number of restricted provisions on it. And it is a fairly unique, though perhaps not as unique a lot as Mrs. McKettrick would have us believe. But at the end of the day, it's unfair.
So if I installed my old house on Cheever Street, if I had installed in my garage an apartment and got away with it for 10 years and kept my house really well maintained, and I needed the income to support my property, that's where I'm tripping up.
Yeah,
But that's different, that's you doing it.
And then I sell it to
Yeah, yeah,
somebody
yeah.
later, and
See,
the
that's the-
assessors came through and
yeah.
mislabeled it, and I don't know.
Yeah,
It's very different from the houses on Cheever Street.
Yeah, I know.
There's a
Well,
lot more room.
There is a lot more room, yeah. That
On
is
this
that,
lot.
and the garage is a lot farther away from the
But
property
I
line
take
than
your
mine
point.
was.
Thank you.
Yeah, I know.
I guess then it becomes, because we're sitting as judges.
I know.
So quasi,
Well, yeah.
and one of the jobs as the judge is to weigh the credibility of the defendant before him, or her, and not that you're a defendant, but but I think for me it comes down to credibility and whatnot, and I'm concerned about leaving this building owner in a worse position than they are already.
And the tenant, right?
yeah,
And the tenant.
who hasn't done anything wrong.
Yeah.
Other
I
than
mean, that's
rent
a-
an apartment that they thought was legal. And I'm, initially I was like, well, wait a minute, you just don't get to have an apartment. How could you not know that it wasn't legal? But That's the real estate attorney in me speaking, sorry. But I think with the conditions that we would include, trying to draft the decision with enough background, borrowing from Ms. McGettrick's detailed information,
As usual.
to sort of provide enough language that makes it look as if it's this special circumstance and not something uniformly applied to anybody that has a nice house with a big carriage house and a yard.
We're granting a use variance, so it's a
Yeah.
little trickier.
Yeah, but I mean, I think, well, you're not bound. I mean, there's all sorts of decisions that say just because the zoning board has given one decision, they don't have to do 100 of them the same way.
Yeah.
So there's a whole line of cases on that. So I'm not as concerned, except for the fact that the precedent, it doesn't look good. But I think that in this in this circumstances, we don't have any objections from any neighbors. We have supporting letters from the
does help.
neighbors. I'm also sensitive to the fact that we are trying to encourage alternative housing in this town, and to preserve the historic houses that are in existence. So, that's a compelling feature for me because of the fact that I own an old Victorian, but I only have 5,000 square feet, so, and no garage. So there wouldn't be anything I'd be able to do. But I think we've been looking through that master plan and discussing at, town meeting ways to preserve the look of the town and the houses that are here. That sort of makes me tilt to say yes.
Okay. Well, I'm thinking. Sorry, I'm thinking so long. I mean, the other, when you were talking, the other point that came to mind, let's just say in favor, is that obviously we want homeowners to seek building permits when they need them, and not to avoid getting them because they're worried about being, told to stop doing something that they're doing. I don't know if that's much of an argument, but
It's a practical
it's a
argument.
practical argument.
Well, I mean, and as said, this is an issue that I've run into in my own practice where, you have a client that wants to buy something and you check on the inspectional services records and they say, wait a minute, it's a single family and you thought you were buying a two. Or it was a single family and it's been improved without any permits. And there isn't really anything you can do. Because you can't go back to the inspectors and say, oh, hi, can you prove the plumbing and the electrical that were installed 10 years ago? That never happens. So,
And are you guys troubled with the length of time argument? I mean, that because it's been wrong for so long that therefore it's okay?
well, I mean, it's been wrong for so long on the improvements that we can't do anything about that.
I know, but I mean on
Yeah.
the use.
On the use, no, I don't think it's okay. I mean, that's why they're here.
Yeah.
And if in a different situation, if we had somebody before us who had created the apartment themselves, I'd be in a completely different place with this.
Yeah.
Well, let me take the other side of it. Is the fact that it's been illegal for so long a factor? Yeah, of course it's a factor. But it's one of several that I put into the mixing bowl, including the fact that there are no objections from the neighbors.
That is a very strong.
Contrast this to a situation where, say, for example, the building commissioner had a complaint from a neighbor, did an inspection, found an illegal apartment, whether it was there for 10 years or 10 months. That's a completely different
Right.
fact pattern in my mind. Here you have essentially an innocent insured, so to speak, to borrow. I'm not a real estate lawyer, I'm the insurance side of things. You've got an innocent insured here, so to speak.
A bona fide purchaser for value, if we were talking about commercial code, which we're
There we
not.
go.
But,
That's why you shouldn't have lawyers on zoning
I
boards, I
know.
guess.
All right. Well, the fact that I guess I would say this, the fact that you've gone out and gotten so much support from so many of your neighbors that the recollection of everyone, well, I know it's hearsay, but everyone that what you've reported them have saying is that it is established that the use of this carriage house as an apartment has been there, well, A, for a long time, and B, has the use of it has been such that everyone thought it was legal and not creating a disturbance in a way that would make people question, why is there an apartment there anyway? On balance of equities, I guess I could come around to supporting it. How's that for, sure, whatever, break some more rules.
Okay,
Okay.
shall we,
Yeah,
anything else?
you know, is there anybody else that needs to talk?
I've got nothing.
So, the idea would be that we would vote the variance to allow the accessory use for the apartment, subject to conditions that there is no expansion to the physical building, only one car, leasing for 1 year or more, and no subleases. Exterior of the carriage house to be preserved in its historic appearance and together with the
How about we preserve it in a manner consistent with
the house.
Yeah.
Because
which
that's
is how that-
that's the standard
Yeah.
language.
Right. So sort of taking the language that we would incorporate in a decision for an accessory apartment that we have for special permits, those kinds of things, we would put into a decision for this one. Does that sound good? All in favor?
Aye.
Aye.
Aye. Congratulations.
Thank you very much for your careful consideration of a
The
difficult
real
one.
estate lawyer for the transaction thanks us as well.
Yeah. Well, 6 years is gone, I suppose he couldn't get caught by malpractice.
This is why we get the big bucks.
But just as a
I
lesson
just
to
wanted to say that.
people out there, if you're looking to buy something and it says that it has an apartment, check the occupancy permit.
This case, I think I need to give you an extension letter, which I will fill out now.
Yes?
Because for a variance, I think it's 100 days from the date of filing to the decision.
Mm-hmm.
And we're actually pretty close to that, because we filed.
August the 22nd, yes.
Yeah. So I will
Yeah.
give you one.
That would be great.
I will do that, and you don't have to approve it, I don't think. I think I just have to agree to extend or something. It says, I wrote it to say, on behalf of the applicants, I agree to an extension of time for whatever amount of time you would like me to say, 2 months?
No, I don't think
It
we,
takes a while to do
Yeah.
these.
So do I need to, like, do anything with my lease to make sure, because, I don't know, what do I need to do to make sure this is okay moving forward, I guess is my, and I can talk to you, I guess, about this.
Yeah, I mean,
Yeah.
whatever conditions are going to be in this variance should be placed, I mean, I don't know the terms of your lease and when it stops, you know, so if it's a yearly lease, what's the term? But I believe your tenant really wants to stay in the apartment. I think you would have to, you should approach your tenant and indicate that there will be conditions on your variance and that the lease needs to contain certain additional
Okay.
conditions and
One,
ask
have a
her
lease.
to.
Step one, have a
Yeah,
lease.
exactly.
You both sign it, an amendment.
Okay.
Does that sound right?
yes.
Step one, have a lease.
So, yeah, so,
Yes.
right.
Yeah.
So we have this extension.
Yeah. Let's see, I'm filling this out now, I don't want to delay your next hearing, but
Thank
I will
you.
fill it out and I will bring it up to you.
Do you want me to take this one?
Sure. I just wrote a long one.
I'll do this one.
Okay.
Okay, so our next hearing, which is it the, what's the next one on the list, Beverly?
Janine.
Janine. So
5 Badger Circle.
5 Belcher Circle, Badger Circle, Badger Circle. And this is a continuation of the hearing that we had last month. where we requested additional information in accordance with the requirements of the provisions of the zoning bylaw. And I believe that these additional information has now been supplied. We have, in addition to what we had as the application dated August 16th, 2018, we now have additional information, a plot plan, pictures of the improvements being installed in the dwelling, and a response to the provisions of Section 9 of our zoning bylaw, giving details on the ownership, who will be occupying the premises, and the designs and modifications proposed to the building. And before us, we have, this evening, hi, how are you?
Hi, I'm
Welcome
Janine.
back. Denise Spiegel. And William, sorry. And so, as I recall, the last time you were here, we didn't have the information that we need for drafting, to just consider this application. And so I see that we now have this additional information. So do you want to just sort of give us a outline again of what you've been proposing?
Should we,
Yeah.
basically, my aunt would like to reside in the basement with a small kitchenette. And the application for the small kitchenette drove us to visit you for a temporary,
Yeah.
not what you just
Yeah,
granted.
right, yeah.
Which was quite interesting to watch, by the way.
Rough justice.
Very interesting. But anyways, we feel that we've provided you the information that was required. We are looking to obtain a temporary judgment.
Special permit. yeah.
Special permit.
Right.
We understand all its ramifications. If my aunt decided to move or what have you, her son could use it at his own leisure, but we cannot rent it and earn any extra money.
Right.
And it's
Yes, and as you
Wait,
had
where we
pointed
are
out
right
the
now.
last time, you're not actually expanding anything in the house.
No.
It's just
No.
putting in a kitchenette
A galley
that was
type
already
of
there. Yes.
Within 80
kitchen,
square
just so I don't
feet
have to be
of-
going
Right.
up and down.
So it is not a major change to
No.
the property. But as I said, last time, we didn't have any indication of what the ownership was and the occupancy was, and now we have that. Any questions people wanted to ask?
No questions.
Is it just an in-law apartment? in
Yes,
there?
it is.
And under the, with
Yep.
all the detailed
Right.
Yeah.
stuff that you
Nothing
get.
what you went
oh,
through
not
for
to-
the last hour, my
Yeah,
friend.
I mean, all this, yeah, no, that's. I
Yeah,
get it.
no, Nick, they're just adding in this little
Yep,
kitchen area
I
in the
understand.
basement.
It's
The
tiny.
basement's already there.
all
You're already
the-
living there, and it was
Yes.
just a problem of
Hardship.
hardship getting up and down the stairs, and nice to make a cup of tea or make a cup of coffee without having.
And then last hearing, we didn't have anything that we could put on
Yeah.
record.
With the real, right, with the plans. And
Yeah,
Yeah.
we had a
relationships.
real,
The
we had,
bylaws
yeah.
so detailed about the
Right,
things that we have to find.
Exactly right. We had to.
We had a
to
real
get some
thin file.
paperwork.
Yeah,
And I-
really thin.
Okay, no, I don't have any questions.
Okay.
Okay.
I'm good.
I'm good. All right. Take a vote. All in favor?
Aye.
Aye. You have your
Thank you very
application.
much.
Thank you.
Appreciate it.
Thank you for your patience.
Thank you. Sometimes,
Sorry they
I know
left
that
it.
sometimes this stuff can be really technical, as you saw, sometimes we have to go through stuff.
Oh,
but,
yeah.
You gotta follow, sometimes you have to follow the rules, and part of this is for your protection as well as for the town's.
Nobody appeals it, and they, well,
Mm-hmm.
or they have fewer grounds.
Sure.
We need to go through what needs to be done in terms of the variance for these folks.
So we will be issuing a decision for this special permit.
Sorry, special permit.
And so that gets drafted by us, it gets filed with Beverly, then she files it with the town clerk. And once the 20-day period has gone by,
20 or 30?
20,
Is it
I think it's 20.
Okay.
Get the application, get the permit, and you're gonna record it at the registry of deeds
Okay.
in Dedham,
Yep.
okay? So, once the 20 days has gone by, nobody objects, then you're good to go, and you can come and see Beverly, get that permit, put that on record.
And then that would be attached to my application of permit, which is
Yeah.
in the file now.
Right, Right.
And then I should get
Yeah,
a
then
building
you'd be able to
permit.
get the building permit, but you have to record it at the registry.
So we can't begin to do any work there until the 20-day period goes by, is that correct?
That's true.
Okay.
Because
I just-
somebody might object.
Okay.
You know, you don't know who, but, you know, they have the right to do
We
that.
gotta give the time frame.
And you'd be at risk, you
Yeah,
know.
of
Right.
course.
And I don't
Yeah.
think that they'll issue the building permit until we've got the decision.
Okay.
Exactly
Okay?
right.
But,
Yeah.
you know, once that's done, it's
Yeah.
pretty quick and
Okay.
you'd be good to go.
All right.
All right?
All right, thank you.
Thank you.
Thank you very much. Have a great evening.
I'm happy to
Can we do
write
that?
this one.
Okay. Oh, that's the stuff we got before. Okay. Thank
on
you
down.
very much. Our last hearing for the night is 99 Granite Place. Is that right, 99?
Correct.
Yes. And it's Teresa Doyle. Teresa Doyle, who's here, she had come in before us on September 27th with a request to do an addition on the back of the house so she needed a variance. And unfortunately, the materials that had been submitted at that time were a plot plan which didn't actually, not that we could understand, give the dimensions and the setbacks. So we were concerned that while we would be willing to give the variance,
I see.
we didn't know the distances. Because the original plan had these kind of weird things in the corner, 98.
didn't know how far
We didn't know,
the
there was no
real
little arrow here to
measurement.
say, okay, fine, what's the measurement? Because we have to write one that says this is
8.6
what.
feet or whatever it is. yeah.
So as you know, Mr. Grace was not on the previous hearing, so we're trying to fill him in quickly.
Sure.
And we appreciate your patience in waiting this long. But the intention is, Ms. Doyle, do you want to explain to Nick
Yeah,
what you
sure.
plan on doing?
We have, well,
You want to?
yeah, so this is our house as it is, without that space right there. So we just were closing this area above this room
Okay.
to make a bedroom.
Great. Awesome. And the problem is that I haven't seen it in the legal ad, so it probably ends up too close to the. to
Yes, and
something.
it was, so, yeah, it's on the, so it's on the
have
second
an
level,
8
and
foot,
it's too
0.6
close
setback.
to the,
Got it. Let me just,
And unfortunately,
Okay. I get it.
as the chair said, that the original plot plan,
Didn't give us the information we needed.
right, we had information from the building inspector, but there was no way that we could look at the plot plan and figure out what the issue was.
So we need, if I'm reading this right, we
Yeah.
need 10 feet and we have 8.64 feet.
yeah, so this is the new plan with everything in red,
Yep.
thankfully recertified by Mr. Nantonino.
There it is.
And not done by one of your kids.
No. It could have been me that night with the red marker, but.
I know. So
Okay.
that we now have the information
Fantastic.
that we didn't last time. And any questions?
No.
Was there any opposition or any of that?
There
any of
was
that
no
nonsense,
opposition.
or support?
And as I said, we did the determination that actually the addition is on the second floor. It is not increasing the footprint
Okay.
in any way. It just,
And I went to all my abutting neighbors and they signed letters of support, so.
Fantastic.
and we have the contract that she has submitted, we have the plan and what she plans to do. As I said, our only issue was that we didn't have a plan that showed how much she needed in terms of the variance.
Which is literally the first time I've seen that.
So it's a foot and a half.
Won the
and it's
lottery.
just-
It felt like exceptional bad luck.
As I said, it was the first time I'd ever seen any of these plans that just didn't give the setback distance. I mean, it was
Yeah, I
like,
definitely thought I had crossed all my Ts,
Yeah.
dotted my Is.
You should have known better, I'm sorry. So, any further discussion?
Now, this is the type of variance that we've
Yeah.
given many times in the
Yeah.
past.
Okay.
Routine.
And so, all in favor?
Aye.
Aye. You have your variance.
Thank you.
So, the same thing, we have to write the decision. We
Okay.
have to file it with the town clerk.
Yep.
20 days, gets recorded,
And
you record it.
And I recorded it in
You
Dedham.
record at the
I heard you
registry at the
said.
Dedham, yeah.
And at that 20-day mark, I can begin building,
Once it's on record,
once I bring it to Dedham.
yeah.
Okay.
Yeah.
Well, you have to go in and get a building permit.
Yeah.
You can come in and get a building permit after the 20-day appeals
Yeah.
period is passed.
After
Yeah.
the 20 days. Okay, so sorry, could you?
So we have to write the decision up.
Okay,
We sign it.
yep,
It gets filed with the town clerk.
okay,
20 days after the date of the filing with the town clerk, you can get a copy of that and record it at the registry.
okay, got it.
And then you can get your building permit.
And then I get building permit. Okay.
Then you can spend a lot of money.
I know, right?
I know Ms. Doyle has a intense nursing program coming up, so.
Yeah, I have one starting in mid-January, so I'm trying to
Trying to
get this.
get your
I'm trying
space
to-
before it gets
Exactly, before I have no ability to be disrupted.
good.
Thank you.
All right.
Congratulations on your
Thank you.
hearing.
Thank you.
Congratulations, and thank you for coming
Thank you.
back. Thank you for giving us the new plan.
Yeah,
That
and
really
thank you,
made a
Beverly's been
difference.
really, really helpful. I'm sure you guys know how helpful she is,
Yeah.
but I
Appreciate
owe you
that.
a lot, thank you.
All right.
All right, thanks a lot.
Thanks.
I'll take this really hard one if you want.
Great.
Yes.
Thank you.